Hello everyone. Welcome to the Kelp ILA webinar. Uh, this is this has been a continued pleasure to host these webinars every month and bring in interesting insights from different spaces of the industry. So today we have something very special for you. Today's webinar is about cross-company complaints under PoSH. If the complainant is from one company and the respondent is from another, does your IC have jurisdiction? So let's jump into what we have for the day. Before that, I would like to speak a little bit about why we do these webinars or where it comes from, the genesis. So this webinar is hosted in collaboration with Indian Lawyers Association and KELP. ILA or Indian Lawyers Association is a voluntary professional organization for the legal professionals of India. The ILA has been formed to shape the future of legal profession throughout India, and it is committed to enable opportunities for quality professional development and enhancement of equality in the legal profession. And it also aims to promote delivery of justice, facilitate effective law reforms, and make effective the rule of law throughout India. So ILA promotes an exchange of information between hundreds of ILA chapters nationwide. Um, Coming to KELP, KELP is established in 2013. It has been working under the guidance of Smita, who has been working in the area of sexual harassment at workplace since before the law of 2013 was passed. KELP was established in 2013 and it is a forward thinking organization committed to revolutionizing workplaces into safe, happy, and inclusive environments. With an unwavering belief that employee well being is integral to organizational success, KELP endeavors to set new standards in HR practices and overall organizational performances. So, KELP is a pioneer in simplifying complexities in the legal understanding of prevention of sexual harassment at the workplace, the PoSH law, and along the way, we also aim to demystify the less understood subject of diversity, equity, and inclusion. So, we have some wonderful panelists for today. I am super excited to announce that we have Dr. Sandhya Advani and Brinda Adige with us today in today's panel. So we are joined by Dr. Sandhya, a little about her, a dynamic professional. She has been in the industry with over 35 years of diverse experience, and she's one of India's leading voices on workplace safety and gender equality. She's a former director of administration at Aclia Solutions. She's a founder of PoSH Systems and has trained more than 66,000 people on PoSH since 2017. Dr. Advani serves as an external member on IC committees for over 40 organizations, bringing deep legal expertise. She's backed in degrees by Ayurveda, law, industrial safety, cyber law, and multiple PoSH certifications. She is widely recognized for her impact. She has received several awards, including the 99 Women Achievers of India and Women's Power Beyond 60 Plus Award for 3 consecutive years. We are honored to have her here with us today. Welcome, Dr. Sandhya. Thank you so much for coming here.
Thank you so much.
And we're also delighted to welcome Ms. Brinda, a distinguished social development professional and a pioneer in child protection and gender justice. She founded India's first child protection helpline, Makkala Sahityavani, recognized internationally for promoting child-friendly policing. A Ford Fellow with training from Columbia University, she has shaped key policing and gender sensitivity modules adopted across Karnataka. Uh, Brinda leads Mukti, an alliance to end human trafficking, serves on Karnataka State High Power Committee, and is external PoSH member for several corporates and government bodies. So she's hearty welcome to you as well for joining us and agreeing to be a part
Thank
of
you
this
very
panel.
much.
Thank you. Now, a little about today's topic. We will be getting deeper into the topic as we proceed. So I will not take up too much time and just tell you what we will be discussing today. So this webinar, we will be discussing IC, whether the IC or the internal committee at the aggrieved woman's workplace has jurisdiction. Does Section 11 limit the jurisdiction or whether it does not limit the jurisdiction? What is the definition of workplace that we are looking at? um, Whether the respondent is needed to be a colleague, and best practices we will be discussing for companies and interpretation of law with a survivor standpoint. And we will also clarify the very confusing two-stage inquiry mechanism that a lot of you have asked us about. Now, I will begin the conversation around this. So my first question would be to demystify the lens of what this judgment is. So what does the new Supreme Court judgment mean for workplace safety in practical terms? Dr. Sandhya, would you want to please take that up for
Sure.
us?
Thank you so much. So earlier on, the understanding was that if a woman was sexually harassed at her workplace by somebody from a different company, the complainant's IC had to send across that complaint to the respondent's IC to conduct the inquiry. Now that has been clarified by the Supreme Court in this judgment, Sohail Malik, that we talk about. Now, in that, the court has clarified the interpretation of Section 11. Now, Section 11 primarily talks about where the respondent is an employee, proceed to make an inquiry into complaint with the provisions of the service rules. If service rules are not applicable, it will be in the prescribed manner. And if it's a domestic worker, it will go to the police. So the court clarified that this is a procedural trigger. It is not saying that the respondent's IC has to handle it. So they have clarified that. Now, because of which it makes life simpler even for the complainant. She can now complain at her own workplace. She doesn't need to go to the respondent's IC, try to find out who are the people. She doesn't need to do that. There is a step-by-step process which has been laid down in this particular judgment. The harasser's employer has to cooperate with the IC of the complainant, right? And it is very, very important for all the organizations to ensure that the ICs are properly trained in this two-step mechanism. They should know about all of it, right? So it has made things easier for the woman so that she can file a complaint with her own IC. She doesn't have to go to the respondent's IC.
Yes. Dr. Sandhya, can I bring up the presentation that you had also
Not at
so
the
kindly
moment. We
brought
can
it
take
up?
it up towards
Okay,
the end. We'll take it up towards the end
sure.
for the two-step process. So we'll talk about it at the time. There's one more thing I can add is that I see now because of this judgment, it has got two roles. One is a fact-finding role, and then the second is to taking action role. So action taking role, first is the fact-finding role, second is the action taken role. And they will have to communicate with the employer of the respondent's company. They cannot wash their hands off. Listen, this person is not from our company. We can't do anything about it. They can't wash their hands off. So they will have to collaborate with the respondent's employer to get all the information, etc., and then proceed further with the inquiry. And here, what also happens, the timelines remain the same. So timelines become critical. You're dependent on the respondent's employer to provide information to you. So it will require a greater collaboration also. So while it has made things simpler for the woman, she can only complain to her IC. She doesn't need to go anywhere else, but it has increased the burden on the IC members.
On that note, I think very well explained. I think it does bring out the fact that now the complainants have to not go around trying to figure out where to file the complaint when they're already so stressed about things that they have undergone, the experience that they have undergone. With that, I also would like to highlight maybe the challenges. Brinda, would you want to pitch in any challenges that you see in interdepartmental queries? Because you do see government and corporate spaces and how they operate. So, what do you foresee as challenges that would come in such interdepartmental situations?
She, she's on mute.
Okay, unmuted. Often we find that the IC committees are not necessarily set up in a robust manner. So that kind of gives us some of those challenges that come up. Secondly, there is a lot of defense itself coming from the IC even before it goes to the respondent. So I think these are some of the issues that we have to anyway contend with. We have been contending with, but the new ruling might also enhance the setting up of the IC because the courts are coming down, monitoring it, and are coming down heavily on these things. Now we are talking about interdepartmental. Interdepartmental will be a slight more challenge because I am sitting also in some of the government departments where the kind of department we understand, if we understand, for instance, I'm sitting with the CID. So it's only for that CID department that this PoSH has been set up. Now, under CID, there are a lot of other departments also come, and we don't know how those PoSH work because the permission has to be taken from a higher authority, from the senior officer. So those areas we have not yet really reached that space, but I'm thinking that because of this new ruling, it might be a little more smoother. Other than that, I can't think of any other major clash or major challenges that might come up. But like I mentioned earlier, there is also the need now where most companies and departments are going very, very strongly into setting up robust ICs. And that I think is a great move.
So I can add a couple of points to what Brinda has said. Number one is to get the other organization to cooperate. That is one. They could delay giving you information, and the delay is going to impact you because you have a deadline, right? They can take their own sweet time to revert with that. There could be a confusion about the roles. Next is the respondent could say, this IC is biased, right? So those are the kind of things. Then maintaining confidentiality across the two organizations. That is another challenge. Then there is also a power imbalance is possible, right? There could be a power imbalance depending on who the respondent is, etc. People who are part of the IC, and many a times the IC members have been trained to handle complaints of their own, employees, etc. Now, because there are different departments, service rules, etc., IC will have to be equipped with the knowledge of how this has to be handled, what are the central government rules, etc. They will have to know about all that, what is the process to be followed. So all this casts a huge responsibility on the ICs. So they have to ensure not that there is a saying in law, justice must not only be done, but must be seen to be done, right? So that is what they will have to follow and ensure that everything is completed in a timely manner. And if once a report is sent to the respondent's employer, if there is no action, then the woman can go ahead and file a complaint. So somewhere or the other, they have to handhold their own employee who has filed a complaint till the entire thing is completed.
I just also like to add to this, just remembered that we know that even now political parties, political bodies are not within this framework. Bar councils are not yet within this framework. And because of that, there is going to be, like Sandhya pointed out, these challenges are going to come up because they don't have to have an IC at all. So how does the IC proceed? Will they respect an IC's letter or email, when a complaint from that side comes up? So these are also going to be big challenges, and the court has not yet addressed it, though the cases are there and the hearing is going on. And the professional hierarchies from a company to a company or a company to a central body or a state body, those hierarchies are going to be a major challenge.
Absolutely. I also see the undermining of PoSH that usually happens. Maybe this will give us a little bit of more authority, legal backing to say that we do have the binding to take action here, or we can give recommendations here. Now you have to abide by it even if you do not have. Now I am also foreseeing maybe a formal internal committee of a company, so taking up a case against somebody who is probably from an unorganized sector. Like I would call even Bar Council of India an unorganized sector at this point, given the in the PoSH purview or the political bodies, because they are not governed by PoSH. Maybe bitterness is coming in how I am expressing it, but it is to say that how are we dealing with it? And there was an earlier best practice that used to be in corporates, that people used to speak to the other, like if uh, it was informal, but one company, if the complainant is from one company, the respondent is from another company, then they would speak to the other company, and both would come together and form joint internal committees so as to eradicate the question of bias from either parties. But now there is a two-stage inquiry process. Does this extend the timelines? Does this allow us to finish one company to finish the inquiry in 90 days and the other to take it up later? So how long does now justice will take in terms of how this implementation will happen is something that we have to wait and see how the implementation of this law is also happening. With that, I come to my next question, that how do you think this ruling will impact the functioning of ICs across organizations? Dr. Sandhya, if you would want to throw some light on it, like what is the impact? How will internal committees interpret it? What are you foreseeing also as an expert? I would like you to bring that up.
So the ICs need to be trained properly what exactly this judgment is talking about. So we can go down to, we can come to that, the two-step inquiry process. What is it? That is, we can go ahead and look at that. But this is talking about the harassment by an employee of another organization, provided this harassment has happened in the course of employment, like it has happened in a workplace or an extended workplace. Now, what is an extended workplace? Any place visited by a woman employee in the course of her employment. The exact term is arising out of and in the course of employment. So what all will it cover? It will cover if she has gone to a client's office for a meeting. It will cover that. It will cover if she's gone for an, party, a get together of the off-site parties, picnics. So it will cover that. It will cover transportation provided by the employer. So if a co-traveler misbehaves or the driver misbehaves, she can file a complaint. It will also cover digital workspaces, right? So anything inappropriate said in a digital workspace, yeah, WhatsApp group chats, WhatsApp messages, emails, telephone calls, SMSs, all of that. It will also cover where a woman employee has traveled for an official event. She's traveled for a conference. Some employee from another organization misbehaves with her. So it will cover incidents which have happened at the workplace or in extended workplaces. So that is one. So that is one thing that they need to check. They need to know how will they conduct an inquiry if they need to reach out to the respondent's employer, provided the person has to give all this information. How do they handle it? What is a two-step process? How will they handle it? So all these things, it is important for the IC to be thoroughly trained, because the timelines remain the same. And now earlier you were dependent on your own organization to take care of things. Now you're depending on another organization to provide things in a timely manner, because for you, the clock is ticking. There is no extension of time. You have to finish it within 90 days, and the respondent's employer has to implement the decision within the 60 days time window. So very important that all this is taken care of. The ICs need to be properly trained. There should be proper SOP or a manual on how to handle this thing, particularly after this judgment, because a lot of times ICs are not very clear. They may know, okay, what is the process and all, but they're not very clear on all the aspects. So if there is an SOP which is prepared, which gives all these things in detail, it will make it easier for them. So what is the template? If they need to request for information from the respondent's employer, what is the draft of the document that they need to send out? All those things. Ensure that there is confidentiality being maintained with the other company also. Otherwise, there could be a breach of confidentiality, which is not okay. right? So all these things need to be taken care of, and the ICs need to be trained accordingly. The employer needs to be more proactive and ensure that this is in place. It cannot be a laid back attitude.
Absolutely. I think now even the compliance with PoSH will come into question for a lot of organizations. If they are not compliant and something happens, the other company can instantly question it, or anyone can question it because they are still valid. And there used to be all these questions that I think we used to get in our training saying, if it's all men in the company, do we still need PoSH?
Yeah.
I mean, we kept saying
Yeah.
you need PoSH, but they would not listen to it a lot of times. And
So
now
I
the
think,
compliance
yeah,
of it comes into play.
Similarly, if there are all women and no men, do we
Yeah,
need PoSH? So I
yeah.
think these questions, there's
yeah,
no doubt. A PoSH
yeah,
committee
this
has
will
to be
come.
set up 10 and more. So we
So
don't want to even ask about genders.
Yeah,
I just want to add something more. You see, what
yes,
is extremely important now, the ministry has set up the SheBox portal,
yeah,
right? Now, the ministry is tracking on a day-to-day basis how many companies have registered, whether they have put the details of the IC members on the portal or not. And those who have not done it, within days, they are receiving notices, right? So, for example, for Delhi, some deadline was 31st of Jan. One client was facing a problem relating to login ID, password, etc. They had done all the hard copy submissions, everything was done, sent it out by email also. On the 12th of Feb, imagine 31st Jan, 12th Feb, they received a notice, you have not uploaded the details on the website, on the portal, SheBox portal. So we wrote to them saying that, this was the problem, we are not able to log in, etc. Then we tried doing forgot password, etc. We were able to log in. But the fact is, they are monitoring on a day-to-day basis. And if you see the SheBox portal, they want you to put in details of the facilitator, the training that you've done, photographs, pictures, etc. So earlier on, people used to say, oh, we've done 2 trainings. There's nobody to check.
Mm.
Now this will be checked, and it will be checked at the click of a mouse. Very, very simple.
absolutely. In fact, even with the district office, the compliance since the judgment in 2024, 2025 on since Aureliano Fernandez, basically, the compliance has been more strict. And now, this year, in fact, a lot of people in the Chennai DO received a response saying these are not filled. You have to fill these fields and send it back. And they have added additional things as per their own district office that you need to be aware of before filing. So, there's so much panic around how to file even annual reports this time that it's a wave, right? We all go through that towards the end of January when everyone's filing. We are all going through this wave. So we did see a lot more strictness in this compliance and the monitoring of whether people are complying or not coming up more. Now coming to like we've talked about the technical aspects of things. Now to think of it as something that does bring out a big thing, big element that we are winning in this is the survivors' ease in reaching out to a familiar face rather than having to figure out those jurisdictions and whatnot, where to go and getting having to deal with so much. So, in the light of this judgment, what does it mean for survivors or your victims to file complaints with the company or whoever is the complainant on behalf of the survivor? So, Brinda, would you want to enlighten it in the sense of how it would look like and what is it that you think would be what is it that we are celebrating here on this particular thing?
Yeah. So this goes more for a lot of companies that outsource an employee or send out somebody to work from one company to another company. And their allegiance is always to this so-called mother company, even though they are working somewhere else. In this particular thing, I think it is now convenient, easier, because the place where the person may be working and the from whom they may be getting a salary are two different uh, entities. Here, they can easily make that reporting or that complaint to the most comfortable one, which is their mother organization. And earlier this was a challenge because often we have found, at least in my experience, I have found that there will be this company that employs a certain cadre of people who work directly in that company, and then another cadre, usually it is people working below them from an outsourced company. And there is always this clash. Technically, the IC should be the same for both. But when a complaint is received about a senior person who's directly being paid a salary from that particular company, the IC itself was not looking at it very favorably. Now they can make this complaint to the IC that they are most comfortable with. And the onus also on that IC to say that, yes, now I have this complaint and I need to take it up. I have also found that many company ICs are unwilling for an observer to also be there. So here, that part of it is now taken care of, where I don't have to write flowery emails requesting that, and please allow us to be there as an observer. But here we have a company, we have a complaint directly to us, and the other companies IC has to facilitate. In fact, the ruling is the employer has to facilitate. So it's not just the IC, the employer has to facilitate. And I think here, the victim survivors, this is a strong point, a strong pillar that they can lean on. And we just hope that, like Sandhya mentioned, the ICs are aptly trained. Often we find that the kind of training that ICs might have, they are either only very, very legal, just with what the law has said and not going anywhere beyond. I think that it is important they not only understand the law in letter, but understand it more in spirit also. That's the only way we will be able to extend the whatever this particular ruling has come up with, to make it more gender sensitive, friendlier to victims, to make the reporting, and a little more authority to the IC itself.
So can I add something here? I just want to ask, how much time, how much of education and experience does it require for a person to be a judge? The person has done 12 plus 3, that is graduation, 15 years, 3 years of LLB, that is 18 years, 2 years of masters in law, at least, that is 20 years, and at least 10 years of practice at the bar. So a person who's sitting as a judge to decide has 30 years of knowledge plus experience, right? 10 years of experience. Now, we have a lot of companies who are reluctant to do longer trainings. They finish it in 2 hours, finish it in 2 hours. 2 hours. Sometimes say, let's do it in 1 hour. Now, you can't be doing it in 1 hour. Whatever you're going to train, the committee is going to take a decision. So they need to be trained well. And this training, this, changing of the mindset of trying to make the people think like judges doesn't happen in a day. It's a gradual process. So regularly they should have, trainings. Every IC meeting also, there should be some kind of knowledge sharing, etc. And they should give it the time. Companies don't want to give that kind of time. So it's very important that they follow this. It will definitely help them in going a long way. If a complaint is not properly handled, person goes and files an appeal, matters will go into the limelight. It will be in the public domain. Can you as an organization afford to be in the limelight for the wrong reasons? You really can't. So it is training the internal committee well is an investment that the company is making.
Yes, complementing to Sandhya's sharing, it is a responsibility of the company directors, the employers, to get in or select IC members who are also interested. See, sometimes we also find that, there are 5, 6 of us, and there are 2 of them who say, I don't know much about PoSH. So you guys go ahead, I'm here to fill the quorum. Now that isn't what we want, because then it does not serve the purpose of the IC. Having a body or 2 bodies sitting there to complete the quorum. And like Sandhya pointed out, that training is very, very important, because very often when an inquiry is going on, those nuanced questions that one must ask and the manner in which it must be asked, you use the word judge, yes, but we cannot even be the judge that we see, the conventional judges that we see in courts, because some of the ICs have lawyers, and lawyers somehow just translate or change themselves when they sit there, behaving like the judge in the court. And those are also times when I have faced certain uncomfortable situations. So it might also make that same situation even more uncomfortable for maybe the respondent, but certainly the complainant or the person who has reported. So the selection of the IC is paramount. Follow through with what the criteria is put, and keep in mind that at the end of the day, it is also the IC's proactive responsibility to ensure that through prevention, observations, you prevent something like this even happening. Don't even wait for it to happen. And it is not only IC's training, we're also talking about the staff and the employees training. Now, every employee who is inducted in the initial stages itself has to go through some kind of a PoSH training online. So the online PoSH training and the exam or test that you might write, and whatever might be the grades that you might get, that's all is the training that some companies give. There is not even in-person training of 1 hour, Dr. Sandhya. And that becomes a bigger challenge, saying that, oh, no, I did not know it was like that. That wasn't the question that was asked over there. This was just done. So all of this must be kept in mind, that at the induction level, you might have an online virtual PoSH training that you might do. But one training must and should be offline, where there are a lot of interactions, question and answers, and if possible, even role plays, because we are a deeply patriarchal society. And this patriarchy is so deeply internalized in both men, women, and trans persons that the unconscious behavior, language, attitudes, all of this, sometimes they say, oh, why are you making such a big thing about something so small? But if something so small is repeatedly done, then it just violates the preamble of the PoSH law itself. And that is why it is important that the training that is given both to the IC as well as to the rest of the company members is done in person. The in-person training, everything said and done, the in-person training is a little more different than the virtual ones. So that training needs to be given that importance and significance.
Absolutely. I completely hear you on that, on where you come from. I would also like to maybe clarify some of the things that maybe we all have different ways of looking at things. So I do see lawyers or HR members sometimes getting very technical about their roles and their education. And it is important that in the PoSH, we are interpreting the essence of the law and not the letter of the law, like you said earlier. And that is where I think a lot of times lawyers tend to go into the letter of the law and be like, oh, this can't be the jurisdiction, this can't be this. So we are used to doing that. I mean, I am guilty of thinking like that maybe 10 years ago myself. But now when I think about it, it is definitely a big learning by being in these spaces that you go beyond the law to understand people. I think a good PoSH trainer is somebody who understands people, is analytical, is inquisitive, has good reasoning, regardless of what background they come from. Somebody who is sensitive about the cause, somebody who knows how to create a space for individuals and also at the same time be firm and assertive in terms of providing those recommendations, regardless. And I think I do have a view on the online and offline trainings because given my uh, experience so far, I have seen a lot of companies operate online. So we have sort of changed the narrative that work can, anything that can be done offline can also be done online. But then I put a caveat to that, that when we are doing online trainings, it has to. I have done some online trainings where wonderful interaction has happened throughout. People are asking questions, they are learning, and there is an ease of access that everyone is coming in online. And I have sometimes noticed that in-person training, sometimes people may hesitate, but in an online space, they will still say what they are thinking in a chat box or in, so that they don't feel like. So I don't know if I completely am 100% with the fact that it has to be in person, but I believe in the quality of the training. It has to be at par with an in-person training. I totally think in-person trainings make a big impact and they are amazing. But if you are doing an online training, then you have to do justice to that online training and not make it a background watch. Like sometimes I do trainings where some 300 people have logged in and I am being showed in some conference rooms and I cannot interact. If I am not having, if I have more than 30, 40 people in an online call, how many people's doubts can I actually take up and resolve? But that's definitely a topic for discussion for we have something very big right now coming up, so I think I'll come back and circle back to this. My passion will remain aside for this one. But coming to the two-stage inquiry process, let's, I think we need to demystify this judgment to go ahead. So we are also getting bunch of questions which we need to start taking up. So Dr. Sandhya, without further ado, would you want to explain the two-stage inquiry process and all the legal concepts that came in through the Dr. Sohail Malik's judgment? Let me just share my screen. You took the effort of bringing us a explainer through a PPT, and I would love to bring that up here.
Sure.
Yes, over to you.
Right. So are we at the very beginning? Yeah. So just go ahead with the first slide. Now, are you on the first slide? The first slide talks about PoSH Act. No, just go to the first slide. Absolutely first slide. Yeah. Just go ahead to the first slide. Yeah, okay. So the Dr. Sohail Malik's judgment is talking about handling complaints where the respondent is from a different company. So it's a cross-organization complaint. The complainant is from one organization, the respondent is from another organization. And how are these handled? So could you go to the next slide, please? Okay. So now let's look at two scenarios. We will look at one scenario where there are no service rules. So what does the IC have to do? So the IC at the complainant's workplace has got full jurisdiction. As I mentioned earlier about Section 11, where the respondent is an employee, etc., it's a procedural trigger. So it is not a constraint that the IC of the respondent's company has to handle it. Our IC can handle it. Now it will go as per the PoSH rules. Could you go to the next slide, please? So as mentioned, the IC has the powers of a civil court. They can summon a person and conduct an inquiry, ask the person to take an oath. They can ask for production of documents. It is not mandatory. They have to only call the people who have been mentioned in the complaint. On their own, they can call others also, right? If they feel somebody will be able to throw some light, they can call someone else also, right? So that is the powers of a civil court. Just can you go back to the slide, please? Then they also have a 90-day deadline that we spoke about. And once they conduct an inquiry, they will prepare the report. After the inquiry is over, within 10 days' time, they have to prepare a report, which is as per the PoSH Act. Next slide, please. Now, if the allegation is proved, they will provide the recommendations. Recommendation is primarily the punishment that we are talking about. Punishment could be a disciplinary punishment. It could be a financial penalty. So they will provide all that information and they will send this across to the respondent's employer. They will provide this information to the complainant, to the respondent, and to the respondent's employer. If the parties are not satisfied, they can file an appeal within a period of 90 days. Employer gets 60 days time to implement the thing. Right. Next slide, please. Now, in case of a company which is governed by service rules, are we clear about if it is not governed by service rules? It follows the PoSH process. The IC will conduct the inquiry. The report will be sent to the respondent's employer, who will go ahead and implement the decisions of the committee, because the IC is a quasi-judicial body. Now, as far as a company which is, where the respondent is governed by service rules, generally the government bodies or PSUs, etc., they have to follow a two-stage process. So what exactly is that? Let's go to the next slide, please. So the IC of the complainant's company will conduct a fact-finding inquiry. They will collect the evidence, speak to various witnesses, assess whether there is a complaint or not. And based on that, whether this person is guilty or not, and they will submit their report. This report is sent to the respondent's employer. Next slide, please. Now here, before it goes to the respondent's employer, in case our IC needs to get some information about the respondent, they can ask for information from the respondent's employer. And because of this judgment, the respondent's employer is duty bound to provide that information, right? He has to provide that information. Next slide, please. And then once the respondent's employer receives it, it goes to the disciplinary authority who will check whether there is a prima facie case or not. And if there is a prima facie case, a formal charge sheet is issued to the person under the CCA rules. Next slide, please. So once a charge sheet is issued to the respondent will either admit it or deny it. If the respondent admits, then the disciplinary authority will decide on the punishment. If the respondent does not admit, say denies it, then it will be referred to the IC at the respondent's workplace who will conduct the necessary inquiry. Next slide, please. Then after the respondent's workplace has conducted a formal inquiry, they will come up to a decision, whether it is getting proved, not getting proved. However, before, remember, principles of natural justice have to be followed. Rule against bias, rule of fair hearing, all those have to be followed. And the respondent's employer, the disciplinary authority will decide on the punishment in that case, right? Next slide, please. So the one thing that the respondent cannot do, he cannot challenge the jurisdiction. Because of this judgment, he cannot challenge. Why is it that the complainant's IC is looking into it? I don't want to go and I don't want to attend. He cannot challenge it. This is mandated by the Supreme Court. He will have to cooperate. If the respondent's employer, if he needs to intervene and inform that, yes, you have to follow this, you have to go ahead, he needs to do it. Next slide, please. So if you see the two scenarios, right? If there are no service rules, IC has full jurisdiction. They will conduct the inquiry within the 90 days, share the report with the respondent's employer. Respondent's employer will go ahead and implement it within a period of 60 days. If the parties are not happy, they can file an appeal within 90 days. In case service rules are applicable, the complainant's IC is a fact-finding body. It will come to a decision whether this is person is guilty, not guilty, and forward this across to the respondent's disciplinary authority, who will then issue a charge sheet, as we talked about. Charge sheet, conduct an inquiry if the person refuses, and then decide on the punishment. So this is the process that is followed. This is a two-step inquiry. That's it. Just go to the next slide. I think we've finished with that. Yeah, we've concluded that. So this is the process that is followed.
Thank you so much. I think it was very, very insightful to also go through it. It was very nicely formatted and also presented. So thank you so much for that effort. It means a lot. Again, now coming to this, we have a lot of questions coming up as well. So in the interest of time, I think we should start taking up those questions which are coming up in the chat for us. Before I do that, I also wanted to, I think some of the questions that we had prepared will be answered in this. So there is a question on a woman coach from an NGO being harassed by minor students in school. So I don't think minors are covered under PoSH Act. They will come under Juvenile Justice Act, and hence we will not be taking it up as a minor. But just a question, like how does this impact, I think we also saw no service rules as a thing. So what do you think as a challenge coming up if NGO person is going to a school? There is a whole change in department. So would you want to throw light on that?
So if she's going to the school, let's see who is the person who, if there are students who are harassing and all that, it will go by those relevant rules, right? It will go by the Juvenile Act.
No, but if it's a teacher or somebody else that they are interacting with.
So, okay, if it's a teacher, then it's a person from a different organization, right? So it'll go
Yeah.
it'll go as per the provisions of the judgment.
Yes, absolutely. Now there is also a question on the respondent's ICC was called to be part of the investigation along with the complainant's IC. Would the two-step investigation need to be followed? I believe it has to be followed, but
It has to be followed. So I would like to ask that person a question. Under what provision of law are you asking the IC of the respondent's company to be present in the inquiry where the complainant's IC is conducting inquiry? Is
yeah,
there a provision in the law? I have not seen it.
yeah, there is none. I told you about this best practice. I think they are
Yes.
doing that because a joint IC. Sometimes when the companies are mutually agreeing, they will be like, okay, let's form a body together and make it happen. But I think that's not within the law as such. And
I have
it's
seen an observer being permitted. So the observer is present and then can see, yes, the inquiry is being conducted in a fair manner. That is what I have seen some companies doing. But
yeah.
even that, there is no legal provision for that. So whether the person from the respondent's company is present or not, all those things, it really doesn't matter.
Hmm.
The law has laid down a certain process. The process needs to be followed. And this process has been laid down by the highest court of the land.
Absolutely. Brinda, there is a question in the chat, other than this, that there is a possibility of witness from respondent side going hostile based on the progress of inquiry, as complainant's IC has no control on these external witnesses. Would you want to take that up?
Yes, sure. So when a witness goes hostile, whether it is from the respondent side or even from the complainant side, because there are certain cases where the complainant side also they have gone hostile. There is nothing that we can do about it except that we can go and talk to them again and again. But let us also remember that many times the respondent's witness hesitantly come because it is some kind of a situation that might be created because they are also from the same workspace, or sometimes they have left the workspace. So there is some kind of a hold, and because of which they come. And when the matter is presented before them, that, did you see something like that? Did you hear? Was something like this that you witnessed and it was taken up and or it was ignored? What was it? Very many times you will find, especially the respondent side, saying, I never really witnessed anything like that. Something like this never happened with me. But it is not with all the witnesses. So if they have, say, 2 or 3 witnesses, and somewhere, when even though you tell confidentiality, don't talk about it, you have to maintain it literally like a secret. Somehow this information of what I spoke before the IC comes up. And that is when we find that the person turns hostile. In fact, just now we are running with a case where we found that the complainant only presented 2 witnesses, while the respondent presented 8 witnesses. And of the 8 witnesses, only 2 of them kept saying, we didn't know, we didn't see, nothing. But then they now want to come back and say that, no, we were not too happy with the questioning. So sometimes we also have a problem with the witnesses coming and telling us that, why did you question us like this? We didn't want to come. They asked us to come. And of the 8, all of them came and spoke. And when we want to ask more questions, 4 of them have turned hostile. There's nothing we can do about it. We can't force them. Nobody can force the witness.
So can
So
I add something to this, particularly with respect to hostile witnesses? And this is extremely important because you may have, co-workers of the respondent coming to give evidence, right? So what needs to be done is, see, what is the reason why people turn hostile? This can happen within the organization. It can happen in a different organization. Why is it that this person has given my name? I will have to leave my work and go and attend this. I don't want to be a part of it. Why should I have to spend time? Every time they'll keep calling me. All these excuses, things are there because of which the witnesses don't want to participate. So what should ideally be done is, once the witness comes in, thank the person for being there, tell them, that whatever they are going to tell is going to make a lot of, it is going to help the IC in coming to the right decision. IC is keeping an open mind about all these things. And they also remind them that it is their obligation to participate in an investigation, and you are going to be speaking to multiple people. If the witness is lying, you will also be able to know about it, and action can be taken if a witness is lying on oath. So all these things, you have to also be at times flexible. The person doesn't want to come to your office. Okay, fine, I'm willing to do it virtually. Or I'm willing to come in the evening at say 6 o'clock. So somewhere or the other, if the IC is flexible and can explain, the importance of their statement, it will help to reduce the hostility, and they would probably be more cooperative. And they should also feel, particularly if it's from the respondent's company, that this IC is going to be fair, absolutely fair. So you explain the process so they know that yes, this IC is going to be fair and will not take a biased decision.
Yes, Dr. Sandhya, I completely agree. The initial introduction when we give to not only the witnesses, but everybody, even the respondent as well as the complainant, that whatever they are going to say, especially the witness, is going to add to the case, help us come out with the most robust findings and a report. We do find that sometimes they grow hostile or they don't want to come, they won't take the call, they won't respond to even coming for a virtual meeting. And at those times, there's nothing that we can do. But like you mentioned, it is not just the time, because it's only one time that we would do, except in some cases where the witness we really want to speak again. Otherwise, most ICs finish with the witness the first time itself. They do not want to come because somewhere they may not have been happy to even come, whether it was true or false, whatever might have been the complaint. So at those times, we find that, especially when the witness is in a position of authority or some senior position, the witnesses are, made to come. They have to come. And at those times, we have found that some of them have, grown hostile. They don't want to respond back, even if it is a question that we've sent by email. Because one person said, you send me the question by email and I will send it back to you. I will record my voice and send it. And nothing happened. They didn't come back. So like you said, the training is important. And it is important, what is the role of that witness? Because I'm calling a witness for the sake of saying that I too have 10 witnesses, then it becomes a challenge again also for the IC. So we want to be careful to say that what is the role of the witness and why that witness is so important. Call 8 witnesses, they will tell you. Talking to 8 witnesses, by then there is no more confidentiality left, because anyway we can't do 8 witnesses on a single day. So these are also things that people must keep in mind. Anybody may be called as a witness. And that is why it is so much more important that each of us take responsibility to ensure that we do not either ignoring these instances that might happen or, being silent bystanders.
Can I add to this point?
Yeah.
Yeah. See, in my experience where I've been part of it, I definitely in one particular case, the respondent brought almost 9 witnesses. Whereas the agreed women, the complainant, had only three witnesses. Still, I found the 9 witnesses' quality of evidence was so pathetic and so poor. And the more the witness they brought, they helped the agreed women far better, because there was total non-corroboration. The non-corroboration means it amounts to fabrication of evidence. So the law is very clear. You have to follow the spirit. You have to follow the process of what has been stipulated and follow principles of natural justice. In such an inquiry, I did terminate the respondent being non-corroborative, fabricated evidence, and did not fulfill the principles of natural justice. And they even threatened us in the inquiry, telling that they will approach all authorities, including all the Women's Rights Commission, Human Rights Commission. We did write the judgment as just like a High Court judge, and I think they got split and they ran away. They had no standing. So the quantum of evidence is less. Of course, when they produce further evidences, I did say, I've observed that so far the witnesses produced were non-corroborative. Further evidence will not, if it does not add any value, we will not allow it to go on, because that should be not be the delaying practice.
A lot of times people bring in character witnesses. So you're not going to allow that.
Yeah.
I was about to say that a lot of times the quality of witnesses, like I think how Mr. Sundararajan also mentioned, that the quality of witness really matters. And there was one respondent who once told us that he wants to bring 35 people to attest to his character because he has never misbehaved in his career. And we had to ask him, what are all these people going to testify about? All of them turned out to be character witnesses. So turns out he has zero witnesses. And everyone he has mentioned are seniors he has worked with, senior or people in the system who are either his team members who will obviously be biased and say that he is a great person. So we had to reject those witnesses in the this of confidentiality. And also when we are talking about witness, we have a right to summon the witness as IC members,
Correct.
but the witness has a right not to testify. They can come in and say, I am not going to speak. But what helps is to remind them that they are under oath and whatever they are speaking needs to be true. And sometimes it does work that they open up and start talking because the oath suddenly makes them conscious of the fact that they are sitting in a formal inquiry and they cannot sib around in this particular situation. But unfortunately, we cannot force anyone to testify. Even in a courtroom, we can't force anyone to testify. If we are even handling a criminal or civil matter, the court will summon the person. It's completely on the witness to not testify as well. And we have to take that as with that pinch of salt that this is what it is. We don't have enough evidence right now. With that, we are again, I think, a little bit like going off the track again, but I would like to bring us back here and maybe ask some final closing thoughts because we are reaching the end. So,
I would like to
what
add
about the
one.
implementation of inquiry report is a good question that has come up. We'll take that up. Mr. Sundararajan, we will have to take this question up because we have only 4 minutes left. So let's resolve that. And I will see if we can add more time on that. Yes. I think there's a question on the implementation, on how this is implemented. I think Dr. Sandhya explained it in her PPT. I would like to just elaborate on this and say that yes, the implementation comes from the complainant's company will do the inquiry. I'm just simplifying it. Will do the inquiry. They will create recommendations. This will go to the respondent's company. They will do a disciplinary inquiry and they will implement those recommendations by concluding the report by adding their own investigation and inquiry. I hope that answers. I would like to get some final thoughts from Brinda and Dr. Sandhya before we close this call today because it was super
I would like
insightful. So
to,
thank you.
I just like to one point because I
Yes, sir.
definitely felt that the esteemed speakers today did bring out the point. In one particular case, let me say I am providing my resource to you, Meenakshi, and that means you are the principal employer of my resources. I given a contract, and your manager was the respondent who committed an offense of sexual harassment on the women employee I had supplied to you.
Yes.
And the agreed women had lodged a complaint in the place of work to the manager and to superseding on the manager to the senior manager. That company did not take action. So the me having provided, when I visited your organization, I did tell that organization, telling that if this is the source where the offense happened, you are bound to conduct an inquiry.
Yes.
In the event you don't conduct an inquiry, I will do it. If I do it, your respondent has to come. If it doesn't come, the law is very clear. The benefit of doubt is given to the women employee. Very clear. So in that case, we'll have to take that. I even know in one particular case, when a fellow deliberately knowing that he'll be caught, he is trapped in his law of evidence, the way the inquiry was conducted, he even abstained from the inquiry and threatened the inquiry officers also, all the team. We immediately conducted the inquiry. We know that will be a threat on the agreed women. We did the inquiry ex parte without giving those 15 days as prescribed by the law for 3 occasions, conducted and terminated him also. We are very glad this happened, much before a case law came in, wherein the case law said the time is only prescriptive, but the IC can take a judgment the way they feel is right and appropriate. So I didn't wait. I terminated, and after 6 months, I got this lock happen. I was so
Okay.
happy.
So I do hear you on that. I think I would like to pitch in here that I
Yes,
think that the judgment talked about it when the inquiry went beyond 90 days because of some delays that were not in the control of IC. It does not, I don't think that the judgment means that you can take action without giving the summons, because it is strictly provided in Aureliano Fernandez versus State of Goa in the Supreme Court judgment that a fair chance needs to be given to both the parties. If someone is threatening, resorting to those means, suspend them pending inquiry. But they need to be given a chance to present their case. If they are not turning up and turning hostile, then we need to take separate action for that. But I would strictly not recommend to not follow the law and close the inquiry without giving 15-day gap in the summons. I think I don't abide by that. With that, I do appreciate that you did take the sense of justice and essence into the fact, and you took a
I can pitch
subjective
in on
action.
his question, Meenakshi. I can
Yes,
pitch in on his question. You see, if you look at the definition of employee under the PoSH Act, it covers co-workers, contract workers, apprentices, probationers, interns, daily wage worker, ad hoc workers, all of them,
everyone. Yeah.
and
and
temporary
also
workers. So it
and
covers
also
all.
Permanent
visitors.
contractors as well.
No,
Yeah.
also visitors, and also who's going to would be workers.
So when we are,
Ap-
yeah. So what we are talking about is, now we are talking about a contract employee. Your contract employee is working at the principal employer's place, and the employee of the principal employer has misbehaved with this contract employee. In such cases, the IC of the principal's employer is bound to conduct an inquiry, and
Correct.
they should be doing it. And secondly, in case if the person is not doing it, there's nothing to stop the woman from filing a complaint on the SheBox portal or approaching the Women and Child Development organization. So those things can be done. But the principal employer's IC is bound to conduct the inquiry.
Correct. You're right. That's what I did.
Yes. It
I
has to
told them,
definitely
yeah,
be subjective. Yes. Yes. Thank you so much. I think we have come to the end of our time today. We will continue discussions. Mr. Sundararajan, thank you so much for always pitching in with so much insight. We really appreciate your presence. And thank you, Dr. Sandhya and Brinda, for coming in today, giving us your valuable time and providing so much insight with your expertise. I really can't thank enough, and hope to have you all again with us. And I hope that this experience was equally wonderful for you as it was for me.
Sure.
So, and all of us. So, thank you so much for bringing this out today.
Thank you so much. And I hope the session has been useful for all of you.
Thank you
yeah,
so
very,
much.
very interesting. It was a very, very thin line gap, and you people have filled it up. It definitely enriching for all of us.
Yeah, just
Thank
remember this law strengthens the victim. It is victim-centric,
Yes,
Yes,
exactly.
absolutely.
survivor-centric.
Exactly.
Yes,
Thank you.
absolutely. Thank you so much, everyone, for coming in and joining our webinars every month and showing so much support. Thank you. It really means a lot. Yes.
Thank you so much.
Thank you.